Hello, this is Tyler versus Hennepin County. It's a Constitution Day presentation for 2023, and I'm Professor Michael Hart at College of Southern Nevada. I would be remiss not to acknowledge a few people who have been very instrumental in recent years in making the Constitution Day at CSN possible. Dr. William Eric Davis, the department chair, Robert O'Mara, our events committee chair, Dr. Kenneth Fernandez, who was a presenter and also has been very instrumental in putting together the website for the Constitution Day over the years, and another one of our presenters, Dr. Francis Carlton. So big thanks to all of them. Now, that said, I am solely responsible for the analysis and opinions in this particular presentation. Why is this case important? Because it addresses the definition of property in the context of the Takings Clause of the Fifth Amendment. So, government can take private property, but not without just compensation. However, who defines what property interest is? Well, at the broadest possible level, property is a collection of interests. It's a bundle of sticks. It's not limited to any one particular thing. There can be a variety of property interests. But who defines property for the purposes specifically of the Takings Clause of the Fifth Amendment? That is really the question here. And the two possible answers, one is given by the state of Minnesota and Hennepin County. Hennepin County is a local government of the state of Minnesota. And their answer is that it is solely within the constitutional competence of a state government to say what is or is not a protected property interest in the context of the Takings Clause. An alternative answer, which was given here by the Supreme Court, is state law is only one source of what property interests are for the purposes of the Takings Clause, but there are also other factors. What are they? Traditional property law principles, historical practice, and courts' precedents. Now, the effect of this decision, I think, was to actually simplify the Takings Clause, the interpretation of the Takings Clause. As we shall see in a minute, Takings Clause has been the subject of a number of contentious cases, with cases really being driven by complex legal and factual considerations. So property is generally important because property is a fence to liberty, as James Madison put it. For the founding generation, property was a very broad concept. Anything that was proper to you was your property. That's very much in vein of the philosophy of John Locke. James Madison at one point even stated that you have a property in your arm, you have a property in your leg, you have a property in your opinion. But what we are dealing here with is a real tangible property, and specifically real estate. And real estate or landed property has been very important throughout American history and was crucial to the founding generation. Young George Washington wrote, "Land is the most permanent estate and the most likely to increase in value." That's very much, I think, in line with the sentiment and the prejudice of the day that believed that less tangible property instruments like stocks, like bonds, and the derivative instruments that we know today, but which they did not necessarily have then, like options and futures, that they are somehow less real. But real estate really is real. Tyler versus Hennepin County is a real estate case. And I think as we go through this case, you will see why it's important in 2023 and beyond, especially if a recession hits and more people end up in the position of Geraldine Tyler, with their property being taken, perhaps by local government for the purposes of selling it to make the government which didn't get its taxes paid, making the government whole. So let's see what happened here. Now, if from the constitutional standpoint, property is protected more than any other right, if you go by the sheer number of mentions in the Constitution, because it's mentioned in Article 1, Section 10, that's the contract clause, the due process clause of the Fifth Amendment, the takings clause of the Fifth Amendment, which is what we're interested in this case, and the due process clause of the 14th Amendment, of course. Now, Tyler versus Hennepin, as I said, the takings clause is at issue, and it says, nor shall private property be taken for public use without just compensation. So what is the legal background? There's over 2 centuries of contentious litigation over property rights, and takings clause cases can be not just complex, but really facts are more important than principles sometimes when it comes to deciding these cases. There are, however, exceptions. Every once in a while, there are clear-cut rules. For example, if the government is exercising its normal police powers, like the power to regulate for safety, health, welfare, and morals of the people, that doesn't trigger the takings clause unless what? Unless the taking is 100% taking. That's Lucas versus South Carolina Coastal Council, 1992. We also have a rule that says if the taking is only temporary, even if it's 100%, but temporary, then there's no takings clause being triggered. Compensation, you're not entitled to compensation. That's Tahoe Sierra Preservation Council versus Tahoe Regional Planning Agency from 2002. Now, let's look at the facts of the case at hand. Geraldine Tyler, who owed more than $15,000 in unpaid taxes, interest, penalties, and fees for a condominium that she owned, she purchased it in 1999 and moved out in 2010 because she was getting old and her family decided to move her to a safer community. So in 2015, that's 5 years between 2010 and 2015, Hennepin County seized her condominium and sold it for $40,000, right? The county kept the roughly $25,000 of the remaining equity. Why? The county based its decision on the state law going back to 1935, which said that a delinquent homeowner does not have property interest in any surplus equity resulting from a tax state. Now, as strange as it sounds to some, this was law not only in the state of Minnesota, but also in 12 other states and in Washington, D.C. So if you owed taxes and you could not pay those, then local government could seize your home, sell it at an auction, and not remit to you any equity which was left over, you see, after taxes, penalties, and interest. So the question here in this case is very straightforward. Did Tyler have a legal property interest in the remaining equity? Was that remaining equity protected by the takings clause of the Fifth Amendment? A second question, was confiscating the remaining equity an excessive fine within the meaning of the excessive fines clause of the Eighth Amendment? Both of these questions were raised at the trial in a district court, federal district court, and the answer by the district court to both questions was no. The district court dismissed the case for failure to state a claim. So the position of the judge in the case was, there's no protected property interest here. You do not have a claim. You don't have a legal claim. Go away. So Geraldine Tyler appealed to the Eighth Circuit Court of Appeals, and that Court of Appeals agreed with the district court, saying, you don't have a claim, Geraldine Tyler. Your property interest is not protected. The state has exercised its legal power to sell your home for non-payment of taxes, and you lose any equity which was left over. Too bad for you. Now, what about the decision of the Supreme Court? The Supreme Court unanimously held, in the opinion written by Chief Justice Roberts, that Minnesota state law may not exempt property tax foreclosure sales from the reach of the takings clause. Tradition, historical practice, and Supreme Court precedent demand that the government may take no more property than is due to satisfy the debt. So there's a total divergence here between what the Supreme Court did unanimously and what the two lower federal courts had done. Thus, taxes, interest, fees, and penalties, those are all constitutional, and those were not even questioned at any point by the counsel for Geraldine Tyler. However, what is not constitutional is the taking of the remaining equity of the property owner. That's out of bounds. That's unconstitutional. As far as the excessive fines clause is concerned, the court as a whole did not address this issue. However, Justice Gorsuch wrote a concurring opinion in which Justice Ketanji Brown Jackson joined, arguing that when a local government keeps any remaining equity, that constitutes an excessive fine, even though the government may not call it a fine. So bottom line, the unanimous ruling in favor of the property owner in this case is a repudiation of the heavy-handed governmental treatment of property owners. It is also a movement, I think, towards simpler and fewer legal rules in Fifth Amendment cases, specifically in the takings clause cases. This was, by some, unexpected, particularly if you keep in mind the previous history. Cases like Lucas, cases like Tahoe Sierra, which I had previously mentioned, those split along ideological lines, with conservatives holding in favor of property owners and liberals in favor of the state. This was not the case here. Here the court unanimously went one way. What can still government do? It can still impose pretty high interest, fees, and penalties. After all, if you look at this particular case, the tax liability of Geraldine Tyler was $2,300. But in 5 years of delinquency, she accumulated $13,000 in interest, fees, and penalties. So those many times exceed the original tax liability. But then like I said, this part was not even contested here. All right? What is interesting and what's likely going to happen once this case goes back to the lower federal court on remand to decide what to do with the excess of $25,000, which the county had unlawfully grabbed, is that Geraldine Tyler may not get all of that $25,000 because in this case, as in many other cases of this nature, there are secondary, tertiary, etc. lien holders. And it does seem like there were, in this case, other lien holders. And this case is typical in that the government typically gets priority when there's a delinquency and taxes are owed or payments are owed, the home is sold. So if the amount of liability to other lien holders is greater than $25,000, and as far as we can make out from the facts of this is that they are, Geraldine Tyler, who is 94 years old, is not going to see a penny of any of the money. But the principle really is what's important, and the principle is private property is now more protected than it was before. The government can no longer take a home and sell it and keep all the remaining equity just because it thinks that's the right way to go. Now, it's interesting, this case, even though it flew under the radar a little bit because of other cases like Students for Fair Admission and 303 Creative, the affirmative action case and the free speech case that were decided this year, which actually kind of suctioned most of the oxygen of the, coverage, I would say, in the media. This case, compared to those, was definitely under the radar, but its importance is suggested not just by everything I said so far, but also other little clues, like the arguments in this case, oral arguments, went for 1 hour and 40 minutes, which is extremely rare under the current Chief Justice John Roberts, who is harsher than his predecessor William Rehnquist in cutting people off, including his own colleagues in mid-sentence, to keep it within about 1 hour. Also, we see that Justice Thomas spoke in this case. He actually opened the questioning of both counsels, the counsel for Tyler and the counsel for Hennepin County. He led in questioning because property rights to him are very important. So the case definitely deserves, I think, everyone's attention. Like I said, when the next recession hits and more people find themselves in the shoes of Geraldine Tyler, those 13 or 14 jurisdictions that used to be able to grab your property and exercise the so-called equity theft and keep what is yours, they won't be able to do this anymore. An important case, and thank you for your attention.